Interference proceedings. Interference refers to situations that are different from the inventors that are claiming the invented substantially for the same invention. Situation arises for the invention claimed to two or more pending of the application filed with the different inventors claim for the application filed with one either after the patent and issues and another inventor. An interference proceeding with the issue instituted the U.S. Patent and Trademark Other Office determined the first inventor entitled to the patent in the prior question to determine the board of the patent interference losing the part of that may seek the redress of the courts. In order to prove the first inventor that you should be comparative contemporaneously records of conception, invention, reduction of the practice predated the records of the office. Other inventor records should be corroborated and be least and preferably two interested, complete, competent witnesses. Evidence and reasonable diligence, practice, and complete the invention. Important to conceive that your invention be owned by the others invented reduced to the practice as they did, as in the event of the interference practicing good keeping suggested in the Chapter 7. It often plays a decisive role. Chapter 12, Incentive Awards to the Army. Each Army inventor includes and is entitled to a $100 award when the patent application is filed for the Army on the invention. Additionally, each inventor is entitled to share a $300 award when the patent is granted to the Trademark Office of the invention. Separate consideration inventor which entitled the suggestion award based on the actual value has invention of the actual value determined to the Army. It means that the Army inventor may receive the award up to $25,000 for the invention that results in substantial improvement of the government operations. Patent infringement. An experiment of the patent article with the sole purpose of gratifying physical taste and courtesy or other amusement is not infringement of the right of the patentee. Walker on Patents on Delaware edition. A patent issues an unauthorized use in making or selling items claimed by the patent constitutable in patent infringement where the government infringes patent and another patent and remedy in suit of the damages the court claims against the United States. 12.13.2 title not assigned. Chapter 14, and I guess that's the review of Chapter 14. What is a copyright? Copyright protects the works of the author against being copied. Some scope of the copyright includes all the kinds of literacy, cryptographic, pictorial, graphic, sculpture, audio, visual, dramatic, musical works. These are works including the written and prevented material, motion pictures, sound recordings, material stored in the computers, readable online only by a machine. Copyright prevents others from creation of the author. It goes only to the form of the expression rather than the subject of the matter in writing. For example, the description of the machine could be copyrighted in writing, but this would only prevent us from copying the description. Copyright would not prevent others from writing description of their own for the other making use of the machine. For another practice is the immersion of the exclusive legal rights granted the Copyright Office to the copyright owner. The copyright reproducing, translation, publishing is infringement of the copyright and punishable by law, awarding to the damages of the copyright owner. There are some exceptions of the copyright owner's exclusive right to the permit the copy distribution of the distribution of a copyright work. To the exception included the fair use of copyright made with the teaching, scholarship, research, and library archives, unless exemption applies, but the must obtain personable copyrighted work which is involved the purchase of a license of the use of the government purpose without the permission could result in liability of the government. Any regulation of 310.1 and contains information procedures to obtain permission to the use of copyrighted material by law. No copyright may be obtained by the work procedure of the government employee as part of his or her official duties. However, any question relating to the copyright works may be directed with the Patent Council and the agency of the Chief Intellectual Property Division, Appendix B. This is trademark protection. It shows the political cartoon. Different manufacturers, Whippy soap versus Whip-Z soap. A name Whip-Z soap and Whippy soap appears confusing and similar to me, but on the the same company probably made both products. Confused consumer. Paragraph not used. Chapter 15. What is a trademark? A trademark may be a distinctive word, name, logo, emblem, symbol, device, combination. Therefore, providing particular identification, distinctive appearance of overall similar goods of others. Trademarks law requires that they mark actually adapt and be used in interstate foreign commerce and establish the exclusive rights to marks. Goodwill built in the effective advertising long-standing of the trademark would be soon lost in imitation downright if not be protected by the courts. So the trademark prevents the use of the same confusing similar name of the same similar goods, but do not prevent the others making the same of the similar goods with the use of the trademark. In order to obtain the trademark protection of the goods, and the trademark application must be filed with the U.S. Patent and Trademark Office. The right of the enforcement is granted with the certification registration issued for the 20 years, renewable additional 20-year period for the long as trademark remains continuously useful. Some areas where the trademark protection could be considerably included, namely identifying the Army equipment such as airplanes, trucks, and communication media publishing the Army's newspaper, periodicals, and generally the area in which the non-governmental sector is likely to participate should be given the consideration of the trademark. Chapter 16, the conclusion of the booklet. Chapter 16, the conclusion of the booklet, touches on some aspects of patent law, purposes of kindling research interest of the patents, Army policy, and encourage stimulated the inventive talents, military, civilian, personnel, obtaining the patents and invitation trademarks considerable to be valuable to the Army mission. The law does not permit copyright official works of the government employees. However, that you are encouraged to consult with a patent consultant of the copyright probabilities. Get started ready on the patent protection. Any inventor should completely copy the invention disclosure from the Form A, Appendix A, the Incentive Right Questionnaire to DA, Page 2871. If you are unanswered to the questions, the patent section for commanded to see Appendix B, Chief Intellectual Property Division, Office of Judge Advocate General, Department of the Army, Washington, D.C. Title 962, the title not used in paragraph. The Appendix A is the invention disclosure. Shows the invention disclosure. It's invention disclosure. It goes over security classifications, foreign and filing consideration, contract information, potential market information, use and sales, publication information, data concerning the invention. Too small to write. And use of the invention disclosure. The address obtained by the assistant in intellectual property matters. The Army commands potential sections of the DARCOM as the Chief Engineer's Office of Command, such as contact Chief Intellectual Property Division, Chief Intellectual Property Division Office of the Judge Advocate General, Department of the Army, Washington, D.C. 20310. DARCOM, Assistant of the Command Council, Patent Law Division, U.S. Army Military Development and Readiness, commanding the 5001 Eisenhower Avenue, Alexandria, Virginia 22333. Chief Engineering Assistant Chief and Patents, DAE-GCP, Washington, D.C. 20310. And followed by the unclassified in my pen.